Hello, welcome all. Now I am going to talk about banking law. This is the first video on banking law. The exam topics here covered are nationalization of banks, its concept, in what way it helped the public and the state, what is the present position or nature, development and evolution of banking in India, general and specific relations between banker and customer, obligation to maintain secrecy of accounts, as case law many times it is asked, precautions to be taken by banker in opening current account in favor of joint stock company and firm. Bankers' right and duties, letters of credit, RBI Act, powers, control of business of banking companies, controlling Indian economy, board of directors, non-banking financial institutions. This has come many times as case law. State the objectives and reasons of the Negotiable Instruments Act 2002, salient features of Negotiable Instruments Act 2002, and Bill of Exchange. Coming to nationalization of banks, banking, the earliest attempt in India in the direction of formulating a definition of bank was that of a Hilton Young Commission put forward that the bank or banker should be interpreted as meaning every person, firm, or company using its description or its title, bank or banker or banking, and every company accepting the deposits of money subject to withdrawal by check, draft, or order. After independence, the banking facilities were not available in all parts of India, and thus at that point the government tried to promote banking facilities to all over India via many reformative steps, and among those steps, one of them was nationalization. Through these steps, insurance companies, oil refineries, electrical companies, etc., were nationalized by the government. Thus, the main motive of the government behind all these was to promote the banks to every corner of India. Coming to history. In the history of banking legislation, two historical events occurred in the year of 1969. They are social control on banking companies, nationalization of 14 major Indian banks, and followed by four further six banks in 1980. Before the social control of commercial banks, the nationalization of these banks had taken roots in India. Social control could not yield desired aim. The crucial decision to nationalize the major Indian banks had its genesis in the Prime Minister's note on the economic policy, which was endorsed at Bangalore session of All India Congress Committee held in July 1969. The ordinance to nationalize the 14 major banks having deposits of 50 crores or more was issued on 19th July 1969. Before the steps of nationalization of Indian banks, only State Bank of India was nationalized. It took place in July 1955 under the SBI Act 1955. Nationalization of seven state banks of India took place in 19th July 1959. On 15th April 1980, six more banks having deposits over 200 crores were nationalized. Till this year, approximately 80% of the banking segment in India were under government ownership, but after this, there was a rise in approximately 80% in deposits and advances took to jump by 11,000%. Brief steps of nationalization. 1948, soon after independence, the Reserve Bank was nationalized. 1955, nationalization of State Bank of India. 1959, nationalization of State Bank of India subsidiaries. 1969, nationalization of 14 major banks. And 1980, nationalization of 6 banks with deposits over 200 crores. Compelling reasons for nationalization of banks. Concentration of wealth and economic power. The foremost reasons for taking the banks was the charge that private banking institutions, being under the control and management of big industrialists and businessmen, were instrumental for the concentration of wealth and economic power through their lending policies. Branch expansion. The private banking companies mainly concentrated their branches in urban areas with the effect that rural areas remained outside the purview of the commercial banks. Public ownership of banks was felt necessary to launch a massive program of branch expansion in unbanked areas. Neglect of agriculture, small-scale industries, and other deserving sectors. It is done because of the risk involved in financing these sectors. Larger share of banks' credits was granted for industry and commerce. Public ownership of banks was felt necessary to make radical changes in the credit practices of these banks. Various malpractices. These banks were indulging in malpractices to favor big businessmen and industries. Those steps were taken through successive legislative measures to stop malpractices. Complete success was not possible without dissociating the private ownership from top management. Change in attitude and outlook was needed. Banking institutions are no more regarded as ordinary business enterprises. They render essential public utility services which ought to be under public ownership. Objects of nationalization. The chief objects of nationalization of banks are elimination of concentration of economic power in the hands of a few, diversification of the flow of bank economic credit towards priority sectors such as agricultural, small industry and exports, weaker sections and backward areas, fostering of new class of entrepreneurs so as to create, sustain and accelerate economic growth, professionalization of bank management, providing adequate training as well as reasonable terms of service to bank staff, extending banking facilities to unbanked rural areas and semi-rural areas to mobilize savings of people to the largest possible extent and to utilize it for productive purposes. The famous bank nationalization case is Rustam Kawaji, also called R.C. Cooper versus Union of India 1970, which is famously known as Bank Nationalization Case, is one of the most important landmark judgments in Indian banking law. It is also based on many principles of Indian Constitution. The so-called the case is so called because the petitioner R.C. Cooper, who was the director of Central Bank of India, one of the 14 banks in the list, and had shares in Bank of Baroda, filed a petition against the Union of India in the year 1969 when many of the banks were being nationalized. On 19th July 1969, the President of India promulgated an ordinance under Article 123(1) of the Constitution of India called the Banking Companies Acquisition and Transfer of Undertakings Ordinance 1969, and as per this ordinance, 14 banks with more than Rs 50 crores deposits got nationalized. An ordinance is basically introduced under Article 123 in such cases when a law is needed to be passed immediately but there is no parliamentary session within that time frame. In this case was that the parliamentary session was only after 2 days from the date on which the ordinance was passed, and thus this issue was raised by R.C. Cooper in the case that what was the emergency that compelled the Indira Gandhi government to introduce the ordinance when they could have easily introduced it as a bill in the parliamentary session? Issues and judgment. The C. Cooper, R.C. Cooper, filed a writ petition in the Supreme Court of India against Union of India, and some major issues were taken up. Some of the issues and the comments of Supreme Court on the same were whether a shareholder can file a petition on behalf of the company. The agreement put forth by R.C. Cooper was that the company does not have any fundamental rights, so it cannot get violated. But due to the said ordinance, as a shareholder of the company, his rights were getting violated and thus he filed a petition for the same. Whereas the respondent argued that according to the Indian Constitution, a company is a juristic body and hence it cannot claim fundamental rights. Whether the ordinance which was passed was properly promulgated, the Supreme Court on this issue mentions that the government has subjective power to issue ordinances. The issue of time was obviously questioning, but the court cannot interfere with the government's power to issue ordinances. Whether Schedule 2 of the ordinance justified, the company would get the compensation amount after 10 years. The Honorable Supreme Court mentioned in this issue that the concept of compensation after 10 years is completely illogical and baseless, and thus the process of compensation as mentioned in Schedule 2 is completely wrong. Coming to next question, general and specific relation between banker and customer. In India, the banking sector forms the basis of economic development of the country. Trust helps in the building a healthy relationship between a banker and a customer. The relationship comes to existence once the banker agrees to open an account in the name of the customer. Coming to banker, the definition of banking is given in section 5B of Banking Regulation Act 1949. Banking means accepting for lending or investment of deposits of money from public payable on demand or otherwise on withdraw or otherwise and withdraws by check, draft or order or otherwise. A bank is a lawful institution that acts as a deposit and lending. Banker. It is stated under Section 3 of the Negotiable Instruments Act 1881 that the term banker includes any person acting as a banker. The banker is an individual who is a dealer of capital or a money dealer. Customer. The term customer is not defined in the Negotiable Instrumental Act 1881. He is a person whose money has been accepted on the footing that the banker will honor up to the amount standing to his credit, irrespective of his connection being of short or long standing. Essential requisites of relation. To constitute a customer, the following essential requisites must be fulfilled. That is, one, bank account, and second, the dealing between the banker and the customer must be of nature of banking process. So, first, the bank account. It is whether it can be a savings account, current account, or fixed deposit, must be opened in the name of the customer. So, account is the nexus to create relation between banker and customer. Coming to the duties of a banker. The duties of a banker are it is the responsibility of the banker not to disclose the personal information given by the customer. A banker should follow the guidelines of the customer. If the banker isn't provided with any guidelines, they can follow the rules and regulations. A banker is obliged to maintain all the details of transaction made by the customer. The banker is obliged to honor the checks of its customers up to the amount standing to the credit of the customer's account. If the banker is wrongly refusing to honor the check, he or she is liable to pay the compensation to the customer. A banker is responsible to withdraw and deposit funds with attention and accuracy. A banker should gather financial information from new and existing clients to prepare their accounts, loans, and determine their creditworthiness. The banker is obliged to advise, assist, and guide the client to meet their financial goals. Rights of a banker. Rights of lion. This is one of the rights that are enjoyed by the banker. Under this right, a banker can keep the goods or properties which are under the possession of the debtor until the loan is repaid by the same. Section 171 of Indian Contracts Act 1872 provides general lion of the following persons: bank or bankers, factors, wharfingers, attorneys of high courts, policy brokers. A banker is only supposed to maintain the collateral but not allowed to sell it. But the banker can sell the collateral after issuing a reasonable notice to the debtor who has defaulted. Case law: Hyderabad Commercial Bank versus Indian Bank. In this case, the bank transferred 13 lakhs from the account of the customer without any authorization. On complaint, bank accepted its mistake and promised to make adjustment, but refused to do so because such transfer is done on the direction of the customer, but the bank cannot produce any evidence. High Court ordered to credit the same amount to customer account. Bank appealed before Supreme Court. The Supreme Court held that the transfer of such heavy amount on oral direction is prejudicial to the interest of the national banks, and it is against public interest, and it will also affect the bank's reputation in the public. Therefore, bank is liable to correct mistake. Right to set off. Right of set off. Under this right, the banker has the right to merge two or more accounts of the customer under the same name in a bank and set off the debt balance in one account and the credit balance in the other, provided the funds belong to the customer. The right to set off can be exercised subject to the fulfillment of the following conditions. The accounts must be in the same name and in the same right. The right can be exercised in respect of debts due and not in respect of future debts or contingent debts. The amount of debts must be settled. The right may be exercised in the absence of an agreement to the contrary. The bankers may exercise this right at his discretion. Right of appropriation. This right is used when a customer who has taken many loans from the bank deposits some money without any instructions. In such cases, the banker can use his right to appropriate the deposited amount to any loan, even to a time-barred debt, after informing the customer about the appropriation. Rule of appropriation has been provided under the sections 59 to 61 of Indian Contract Act 1872. They provide appropriation as follows: appropriation by the debtor dealt under section 59, appropriation by creditor dealt under section 60, and appropriation by law dealt under 61. Right to charge interest and commission. Every Bank of India has the right to charge interest on the loans they provided to their customers. The interest are charged monthly, quarterly, semi-annually, or annually. Along with interest, the banks also have the right to levy commissions for the services they are rendering for their customers, like SMS notification service, multi-city check service, retail banking, etc. Right to close the account. After sending a written intimation to the customer, the banker has the right to close an account if it is found to be not operated properly. Right to ask succession certificate. Qualifications of a customer under the guidelines of RBI. A person or entity that maintains an account and has a business relationship with the bank. Any person or entity connected with a financial transaction can pose significant reputation or other risks to the bank, say wire transfer or issue of high value demand draft as a single transaction. One on whose behalf the account is maintained. Beneficiaries of transactions conducted by professional intermediaries such as stockbrokers, chartered accountants, solicitors, etc., as permitted under the law. Obligations of the customer. The customer should read the most important terms and conditions of the bank. They should ensure that they have repaid their dues in on time. Customers should provide authentic information in the records of the bank. If the customer found any forgery in the check, they should inform the bank immediately. The customer should inform the bank if they lost their check. The customer should fill their check properly. The customer should only present their negotiable instruments during the business hours. The customer should inform the bank in case of any disagreement in the bank statement. Rights of the customer. Right to grievance, redressal, and compensation. The customer has the right to a grievance redressal system if the bank fails to adhere to its basic norms. If the complaint isn't resolved by the bank, the customer can go to the banking ombudsman. Right to privacy. The bank is obliged to respect the privacy of the customer by keeping the personal information of the customer confidential. Bankers can only disclose such information in matters of law or with the permission of a customer. Right to the suitability. Under this right, the bank should always sell the products by taking into consideration the needs of the customer. Right of transparent, fair, and honest dealing. The contract between bank and the customer should be easily understood by the common man. The bank should make the customer aware of the major aspects like interest rates and risk involved, etc. It is the reasonability of the bank not to hide anything from the customer before signing the agreement. Right to fair treatment. The customers have the right to not be discriminated against based on caste, creed, gender, sex, religion, etc. by the bank. But the bank can offer schemes which are designated for a particular set of people. The relationship between banker and customer. The relationship between banker and the customer varies according to the type of customer and the service he or she deemed. There are two main relationships between the banker and the customer. They are general relationship. It consists of the possible services the banker provides to the customer. Special relationship, it consists of duties and instruments to the banker. General relationship between the banker and customer. The general relationship between the banker and customer are debtor and creditor. When the customer fills and signs account opening form, he or she enters into a contract with the bank. And when the customer deposits money in their account, the customers become a creditor and the banker becomes a debtor. The bank can utilize the amount in the way they want. They aren't bound to inform the creditor about the utilization and aren't bound to give any security to the depositor. The banks are liable to give the amount back when the depositor demands. Lending money by providing loans is one of the major aspects of banks. They provide loans by charging a particular amount of interest but by utilizing the resources mobilized by them. In this case, the bank becomes a creditor and the customer becomes a debtor. But here, the bank requires security and documents for providing loans. Case laws. Anumati versus Punjab Regional Bank. In this, Supreme Court held that a fixed deposit in the joint names of two persons is nothing but a joint account, which, as the name itself suggests, is repayable on the expiration of the agreed period. Velji Lakhamse versus Company versus Dr. Banerjee. The Bombay High Court has thrown further light on the relation between the banker and customer by holding that the relation is that of a debtor and creditor. Any amount due by the banker to the customer in that relationship cannot be claimed by the customer from the bank as a preferential creditor if the bank is wound up. Trustee and beneficiary relationship. Section 3 of the Indian Trust Act 1882 describes trust as an obligation annexed to the ownership of the property and arising out of a confidence reposed in and accepted by the owner or declared and accepted by him for the benefit of another or of another and the owner. Here, the relationship between the bank and the customer is based on trust. When the bank receives a valuable asset or document for security in exchange for a loan provided by the bank is considered to be a trustee and the customer is considered to be a beneficiary. Canara Bank versus Canara Sales Corporation. The Supreme Court held that there is always an element of trust between the bank and its customer. The bank's business depends upon this trust. Principal and agent. An agent is a person who acts as the one who is employed to do any act for another or to represent another in dealings with the third person. The person for whom the work is done or to whom it is represented is called the principal. Bank carry payments to various authorities by collecting checks, bills, or on behalf of the customers. Here, bank acts according to the guidelines of the customer and charges for services rendered to them. Wilji Lakhamse versus Banerjee. The Bombay High Court has thrown further light on the relation between banker and customer by holding that the relation is that of a debtor and creditor. Because the customer may give certain specific directions to the bank, then bank will be an agent of the customer. Example, A entrusts 50,000 to his banker B for buying securities of stated particulars. B's position is an agent of A. Lessor and lessee. Section 105 of the Transfer of Property Act 1882 had defined the term lease as a lease is of immovable property is a transfer of a right to enjoy such property made for certain time, express or implied, or in perpetuity in consideration of a price paid or promised, or of money, a share of crops, service, or any other thing of value to be rendered periodically or on specific occasions to the transferor by the transferee who accepts the transfer on such terms. The important terms that comes under section 105 are lessor, the person who transfers the immovable property; lessee, the persons to whom the property is transferred; premium, to obtain a lease of an immovable property, a price called premium is paid; rent, the service of or money that is rendered is known as rent. Bailer and bailee. The bailment is a contract where the customer provides a valuable asset or any specific period for a specific period of time to the banker. The customer who entrusts the asset to the banker is a bailer, and the banker to whom the asset is entrusted for the specific time is called a bailee. Bankers also charge a particular amount for the bailment. Amitabh, Amitabh Das Gupta versus Union Bank of India. So in this case, this is a case relating to lockers. It is held that in order to constitute bailment under Section 148 of the Indian Contract Act 1872, delivery of the article is sine qua non, that is, actual exclusive possession of the property must be given by the hirer of the locker to the bank, advisor and client. The banker acts as an advisor when the customer invests in securities. Here, the customer is the client. The banker should be cautious while giving advice officially or unofficially. Special relationship between banker and customer. The special relationship between banker and its customer may be studied in the following headings: general obligations of a banker towards customer, rights of bankers, obligations and rights of a customer. Bankers' obligations, that is, statutory duties of banks. The general obligations of banker towards customers are grouped under obligations to honor checks, obligations to maintain secrecy of amounts, obligations to honor guarantee, obligation to honor letter of credit, obligation to recovery of debts by legal means, dropping box for the collection of checks under bank's liability, to maintain correct account of customer, obligation of banker not to convert excess credit as overdraft. Special relationship between banker and customer. The obligation of bankers to maintain records. The banker should maintain records of transactions, deposits, loans, and investments done by the customer. The records should be clear and genuine. Any irregularity in records must lead to legal trouble for the banker and the customer. In case of State Bank of India versus National Open School Society, this is the landmark case in India where principles are laid down regarding the maintenance of correct records. The obligation of banker to maintain confidentiality or secrecy. The bank is responsible to keep all the information and details of the customers safe and secure. Even though the information is confidential, the information can be disclosed to government officials in terms of any legal issues. This comes many times as case law. Tornier's case. Tornier versus National Provincial and Union Bank of England. This is the landmark case where the bank is made to keep confidential the information of the account of the customer. In India, the obligation of Indian bankers to maintain secrecy was made compulsory in 1970. The general rule about the secrecy of customers' accounts may be dispensed within the following circumstances, and the law requires such disclosure to be made, and when the practices and usages amongst the bankers permit such disclosure. Disclosure of information required by law. A banker is under the statutory obligation to disclose information relating to his customer's account when the law specifically requires him to do so. Income Tax Act 1961 under sections 131 and 133 of the income tax authorities are thus authorized to call for necessary information from the banker for the purpose of assessment of bankers' customers. Companies Act 1956 when the central government appoints an inspector to investigate the affairs of any joint stock company under section 235 or 237. Thus, the banker is under obligation to disclose all information regarding the company but not to any other customer for the purpose of such investigation, which is discussed under section 251 by order of the court under the Bankers Book Evidence Act 1891. Disclosure permitted by bankers' practices and usages. The practices and usages of customary amongst bankers permit the disclosure of certain information under the following circumstances. When the express or implied consent of the customer, the bankers may disclose the state of his customer's account in order to legally protect his own interest. Banker's references. Banker follows the practice of making necessary inquiries about the customers, their sureties or acceptors of the bills from the other bankers. Duty to the public to disclose. Bankers may justifiably disclose any information relating to his customer's account when it is when it is his duty to the public to disclose such information. The obligation of banker to honor checks. The banker is responsible to provide the check of the customer equivalent to the sum of the money present in their account. The conditions that needed to be fulfilled while honoring the check of the customer under Section 31 of the Negotiable Instrument Act 1881. That is, proper design of check should be properly presented, the check should be collected only on banking hours, the correctness of the check should be noticed, availability of sufficient funds of the customer. Coming to loans, bank is the main source of funds is bank's main source of funds is deposits. These deposits are repayable on demand or after a specific time. Hence, banks should deploy such funds very carefully. Generally, the banks use their funds for loan assets and investments. While deploying funds as loans and advances, banks should ensure that certain lending principles are followed by them. Banks should give importance to the principles of lending. Loan definition. The loan is a preset amount of money lent by one party to the another in exchange for future repayment of total value of loan along with the interest and other finance charges. It comes into picture when one source requests a specific amount of funds to another source for a certain time duration. A key feature of loan is predictability. Types of loans. There are different types of loans available across public and private sector banks in India. Here, five types of loans are discussed. Secured loans, that is, loans against fixed deposits, home loans, gold loans, loans against property. Unsecured loans, personal loans, short-term business loans, vehicle loans, education loans, etc. Demand loans, subsidized loans, concessional loans, and others are term loans, bank overdraft facilities, letter of credit, bank guarantee, lease finance, SME collateral free loans, construction equipment loan, SME credit card. Coming to letter of credit, this is very short, a very important short notes. It is a document provided by a financial institution assuring the payment to a seller with an obligation that certain documents have been presented to the bank. A letter of credit guarantees that the payment will be made as long as the services are ongoing. A letter of credit works like a guarantee to the seller that they will be paid as per the terms and conditions. It is normally used in trade financing when the goods are sold to the customers in the foreign countries or the trading parties are not familiar with each other. Coming to Reserve Bank of India. This is discussed under the following headings like Board of Directors, powers, control of business of banking companies, controlling Indian economy, and non-banking financial institutions, which has been asked as many times as case law. Coming to introduction, the Reserve Bank of India is the nation's central bank and is also known as Bankers Bank. It began its operations on April 1st, 1935 under the Reserve Bank of India Act. The Reserve Bank of India origins can be traced to 1926 when the Hilton Young Commission, known as Royal Commission on Indian Currency and Finance, urged to create a central bank of India to separate the control of currency and credit from the government and to extend the banking facilities throughout the nation. Hence, it was the Reserve Bank of India Act of 1934 that led to the establishment of Reserve Bank and set in motion various actions that led to the start of the operations in 1935. RBI was established in 1948 by taking over by the government. On January 1st, 1949, the Reserve Bank of India started functioning as a state-owned central banking institution with a central office at Mumbai. The objectives of RBI are: RBI is entirely operated and owned by Government of India, and the preamble of RBI describes the basic objectives of the RBI, which are as follows: to regulate the issue of banknotes, securing monetary stability in India, to operate the currency and credit system of India to its advantage. The RBI's main objective is to conduct consolidated supervision of India's financial sector, which consists of financial institutions, commercial banks, and non-banking financial firms. The goal of the bank's management is to maintain price stability and ensures credit is reaching the productive economic sectors. There are various functions of Reserve Bank of India like not issuing agency, note issuing agency, bankers bank, controller of credit, banker to the government, lender of last resort, manages exchange rate or currency, manages price stability. The RBI functions as a supervisor and regulator of the overall financial system. Due to this, it brings more confidence in the public towards the national financial system as it protects interest rates and provides positive banking alternatives to the public at large. The RBI also acts as the issuer of the national currency. Organizational structure. The Central Board of Directors retains the topmost position in the Reserve Bank's organizational structure. Under the provisions of the Reserve Bank of India Act 1934, the Central Board of Directors gets appointed by the government. The Reserve Bank's chief executive is the governor who directs and supervises the affairs and business of the RBI. The management team includes the deputy governors and the executive directors. Board of Directors. The central government appoints 14 directors on the central board, which consists of one director each from 4 local boards. The other 10 directors represent various sectors of the economy such as industry, trade, agriculture, and professions. All these appointments are made for a period of 4 years. Government even nominates one government official as a director to represent the government, and he or she usually the finance secretary to the government of India and remains on the board during the pleasure of the central government. Moreover, the Reserve Bank governor and a max of 4 deputy governors are ex officio directors on the central board as well. The powers of RBI in Internet and Mobile Association of India versus RBI AIR 2021, the Supreme Court has explained the general powers of the Reserve Bank of India. RBI Act 1934 The Banking Regulation Act 1949 and Payment and Settlement System Act 2007 cumulatively recognize and also confer very wide powers upon RBI. They are to operate the currency and credit system of the country to its advantage, take over the management of the currency from central government, to have the sole right to make and issue banknotes, and that would constitute legal tender at any place in India, to regulate the financial system of the country to its advantage, to have a say in the determination of inflation target in terms of the consumer price index, to have complete control over banking companies, and to regulate and supervise payment systems, to describe standards and guidelines for the proper and efficient management of the payment systems, to issue directions to a payment system or a system participant which in RBI's opinion is engaging in any act that is likely to result in systemic risk being inadequately controlled or is likely to affect the payment system, the monetary policy or credit policy of the country, to issue directions to the system providers or the system participants or any other person generally, and to regulate the payment systems or in the interest of management or operation of the any of the payment system in the public interest. Other functions which relate to powers of RBI are cumulative powers and functions of the RBI may be classified as follows. To transact government business, which is dealt in sections 20, 21, 21A and 21B. Issuance of currency, section 22 provides the right to issue banknotes. Section 23 provides issue department, talks about issue department. Section 24 talks about demonetization of notes. Bankers Bank, Section 17, lender of the last resort by providing financial assistance. Section 17, Class 4, says RBI to grant loans and advances to the banks. Controller of banks is dealt under sections 22, 23, 35A, 35AA, 36AB, 37 and 45. Controller of credits dealt under section 21, 35A. Compliance of statutory reserves, cash reserve ratio, which is discussed under section 42. Collection of information discussed under section 45B, that collect information as it may think and furnish information to any banking company. Maintenance of external value, that is foreign exchange, dealt under section 40. Monetary controller of, this is the monetary controller of the country. Other promotional and developmental functions are encouraging banks to expand to suburban, village, etc. Establishing deposit insurance corporation. Appointment of agents. Case laws on powers of RBI. India Smile versus Union of India 2015, it was held that in the absence of any specific allegation writ, court cannot interfere with the matter and cannot sit as an expert to decide how much quantity of coins could be brought into circulation. The aggrieved party directed to approach concerned authorities of RBI or other commercial banks if any illegal activities is noticed. Raghunath Shankar Kelkar versus Union of India. It was held that memorandum of standing entered into between Government of India and Reserve Bank for introduction of market stabilization scheme is not referable to provisions of section 21 clause 1 at subclass 2. Hence, it is not required to be laid before Parliament. Coming to Negotiable Instruments Act 2002. This is discussed under the following headings like introduction, objectives, reasons, salient features, and case laws. Coming to introduction, the Negotiable Instrument Act was promulgated in the year 1881. It came into force on 1st March 1882 as NI Act 1881. It was introduced to ease the growth of banking and commercial transactions. The basic purpose was to legalize the system of negotiable instruments. The Act was enforced during British rule, and to date most of the provisions still remain unchanged. The definition is given under section 13, defines as a negotiable instrument means a promissory note, bill of exchange or check payable either in order or to the bearer. Payable to either to order or to bearer. The Negotiable Instruments Act deals with the negotiable instruments and the law governing them, but it does not define a negotiable instrument. The instrument bears the promise to pay the sum of money at an assigned future date or on demand, as the case may be. For an instrument to be negotiable, it must be signed with a mark or signature by the maker of the instrument, that is, the one who issues drafts. The person who promises the amount of money is known as the drawer of the funds, and the person receiving it is known as the drawer of the funds. Characteristics are salient features of the negotiable instruments. Some of the essential characteristics provide a distinctive identity. They are under discussed under the following headings. It should be in writing. That should be negotiable. That there should be a contract to pay money and acquisition for a better title. There should be a legal ownership, payable to order or payer, and there should be some consideration in the transaction. That is, in writing, the instrument must be in writing. It may be typed or printed or by handwriting, except check there is no prescribed form of bill or note. But the other bill or note should be written in the form where all characteristic features are included. Section 20 of the Act requires that negotiable instruments except checks should be stamped. The subject matter and parties to the instrument must be in writing and signed by them. Negotiability. The negotiability has the same meaning as transferability. Negotiable instruments are exception to general principle relating to transfer of property. Nemo dat quod non debt. No one can transfer a better title than himself has. Section 14 of the Act defines negotiation. Section 15 of Act provides how an instrument can be negotiated. Negotiability is not necessary. Sometimes it is not necessary to be negotiable. Example, a check crossed with account payee only may be regarded not negotiable check, though it is regarded as check and negotiable instrument. Contract to pay money. Negotiable instrument contain a contract to pay a certain sum of money. In a promissory note, it contains a promise to pay money. In bill of exchange and check, it contains an order to pay money. Acquisition of better title. The holder of an NI gets a better title from the person who has a defective title or no title or even a thief or a finder, provided that the holder has acquired it in good faith for consideration without notice of any defect in the title of transfer. Even the title of holder in due course cannot be affected by any defect in the transferor's title or any prior party to that. Legal ownership. The holder of negotiable instrument become owner of the instrument, and such holder is entitled to possession of the instrument in his own name. He is entitled to negotiate it. He is entitled to enforce the claim under the instrument in his own name, payable to order or bearer. Consideration. NI contains a specific contract to pay money, therefore consideration must be there in order to support a valid contract. Section 118A of NI Act 1881 provides that every negotiable instrument, when it has been accepted, endorsed, negotiated, or transferred, was accepted, endorsed, negotiated, or transferred for consideration. But this presumption is debatable. In case laws, T. Nagaraj versus Padmavati, the Supreme Court held that in case of tampered promissory note for which no consideration had ever passed from the plaintiff, the defendant cannot be held liable. Why Vijay Kishore versus Brahmananda Rao? The Andhra Pradesh High Court gave judgment the maker alleged to have borrowed sum of rupees 27,500 from A, that is creditor, on 19/9/90 and executed a promissory note undertaking to repay it said amount with interest at the rate of 24% per annum. A endorsed the promissory note to the appellant Y.V. Kishore for the same consideration of 27,500 on 18/10/90. The appellant filed instant suit for recovery against the respondent on the basis of endorsement. The appellant failed to give proper explanation as to circumstances under which the said promissory note came into existence. Above all, capacity of A to lend the amount to respondent was also not established a source of income. The finding of the court was that execution of promissory note or payment of consideration was not proved. Hence, the trial court dismissed the suit, and on appeal, the High Court dismissed the appeal on the same ground. Types of NI. Most of the negotiable instruments transactions can be categorized into three parts. The railway receipts or delivery orders are also common examples of negotiable instruments. The three parts are promissory notes, bill of exchange, check. The promissory notes, that is, this transaction generally takes place between a debtor and the creditor. The debtor creates the instrument promising the amount of money on a specified date. Bill of exchange. This is just an opposite of the promissory notes, as this is an order from the creditor to the debtor. Hence, here the creditor makes the instrument that instructs the debtor to pay the payee a certain amount of money. The bill is created by the creditor. Coming to check, this is just one of the forms of the bill of exchange. In this case, the drawee is a bank and such checks are payable on the demand. The bank is instructed by the credit debtor to pay a certain amount of money to the assigned payee. Other kinds of negotiable instruments are inland and foreign instruments, ambiguous instruments and unclean instruments, bearer and order instruments, inchoate and complete instruments, time and demand instruments, open and crossed checks. This is just for a completion sake. Promissory note. It is also known as pronote. Section 4 of the Act defines as a promissory note is an instrument in writing containing unconditional undertaking signed by a maker to pay a certain amount of sum of money only to or to the order of a certain person or to bearer of the instrument. Illustrations. A signs instruments in the following terms. I promise to pay B or order rupees 500. Mr. B, I owes to rupees 1000. I promise to pay B rupees 500 7 days after my marriage with C. In case of K. Vijaykumaran versus Ajit Kumar, it was held that recitals stating that on demand promisor undertakes to pay a sum of 8 lakhs to promise with interest of 18% per annum for value received. The specimen which is written as rupees 5000 dated and place where this has been written, like Gorakhpur, dated on November 15, 2008. 3 months after the date, I promise to pay to be or bearer bearer, the name should be written, the sum of rupees 5000 for their value received. Signature of the person who is writing this note. The essentials of promissory note are that should be in writing, an undertaking to pay, unconditional promise, signed by the maker, the sum must be certain, and that should be money only. The parties must be certain, that must be stamped, and the and consideration should be present. In Packing Paper Mills versus Vinalata Khosla, the Delhi High Court was of opinion that a promissory note can be made lawful by paying a required stamp with penalty. From this, it is evident that stamping of the note from the beginning is not necessary, and without it note will be valid, but after paying stamp duty, the note can be made binding. Coming to Bill of Exchange. Section 5 defines Bill of Exchange. The Bill of Exchange is an instrument in writing containing unconditional order signed by the maker directing a certain person to pay a sum of money only to or to the order of a certain person or to the bearer of the instrument. See, this is similarly written like a promissory note, and the drawee and the drawer should be both should sign here. This is the usual form of bill of exchange. No particular form is required. It must substantially comply with the requirements of Section 5. The essentials of bill of exchange are that should be in writing, that should be an order to pay. In promissory note, that is a promise to pay. Here, an order to pay. Unconditional order should be there, and there should be money only in exchange. Parties must be certain, it must be signed, and it must be stamped. There is no need of stamping in check. Coming to differences between promissory note and bill of exchange. As to the parties, two parties are called maker and payee. In bill of exchange, they are called drawer, drawee, and payee. There are three parties in bill of exchange. As to the liability, liability of maker is primary. In the bill of exchange, the liability of drawer is secondary. Order, it involves unconditional promise. It also involves Bill of exchange also involves unconditional order. As to acceptance, it does not require acceptance. It requires acceptance of the drawee. In Bill of Exchange, applicability of provisions of the Act. It is not applicable here in promissory note, and it is applicable here only in Bill of Exchange. As to relation of parties, the payee has direct relation to the maker. Payee has direct relation with the acceptor and not with the maker of the bill in Bill of Exchange. As to dishonor, in promissory note, dishonored only by non-payment. In Bill of Exchange, dishonored by non-acceptance and by non-payment as well thereof. Debtor and creditor. In this, in promissory note, there exists a relation of debtor and creditor between maker and payee. Such debtor and creditor relationship exists between drawer and drawer. And as to protest, protest is in case of dishonor is not required. In case of dishonor, it is required. It is necessary in bill of exchange. Bill of exchange taken as a pronote, where the drawer and the drawee is one person, and where the drawee is incompetent person. Discharge of instrument. Maker makes payment in due course. The note stands discharged. Payment by acceptor in due course discharges the bill. Coming to the check. It is the most significant negotiable instrument. Section 6. Check has 6 letters. So remember like that. Check section 6 of the Act defines check is a bill of exchange on a specified banker and not expressed to be payable otherwise than on demand, and it provides the electronic image of a truncated check and a check in the electronic form. A check in electronic form dealt under section 6 clause A means a check which contains the exact mirror image of the paper check and is generated, written and signed in a secure system with the use of digital signature. Truncated check, which means a check which is truncated during the course of a clearing cycle either by the clearing house or by the bank immediately on generation of an electronic image for transmission, substituting the further physical movement of the check in writing. Essentials of check. The essentials of check may be found by the combined effect of section 5 and 6. According to section 5, that it must be in writing, it is an order to pay, it is an unconditional order, and the money only should be written there, and the parties must be certain. Check must be signed by the drawer. According to section 6, drawee must be a banker, always payable on demand. The parties to the check. There are three parties like drawer who draws the check, drawee to whom the order of payment is made. It is always a banker, and the payee who is to receive the payment from the banker. Regarding check and its other functions like dishonor of checks, all those will be discussed in the next video. Thank you. Please like, share, comment, and subscribe.